And I suppose just by way of introduction, we were, I don't know if people have introduced themselves. That's probably the best. You've done me. So yeah, we were really impressed with the list of issues that you'd raised, which we assume are from your day-to-day caseload. We had a discussion about, a preliminary discussion amongst ourselves about the sorts of issues that you're obviously coming across in your practice that we agree need to be thought through as potential judicial reviews. Obviously, there's a distinction or there's an issue always about can we get a remedy for whatever the failure is in the course of family proceedings, but are we seeing issues that actually could properly be identified as discrete judicial review issues? And it seems that from the description of your caseload and the issues that are arising, there's a combination of factors that do appear to be systemic issues in terms of delay in access to assessments, in provision of services by local authorities, that's a kind of theme of some of the issues that are arising. And that if you're seeing that as, obviously it's important in an individual case, but if you're also seeing it as a general problem, then that may also be an important point to take by way of judicial review, if it's illustrating that this is a general failure. And certainly some of the practice that myself and other members of the public law team have been working on in the context of a crossover with immigration and family law, the unaccompanied asylum-seeking children, for example, looking at local authorities and the services that they are and they aren't providing is obviously a big part of work that we do. But increasingly looking at why it might be that local authorities are not able to meet their duties in circumstances where the Home Office puts them in a position that they just, although they may be mandatory duties on the local authority, they're not being funded to do the work, to deal with the numbers of cases that are arising. So, for example, recently I've been involved in litigation, Gwenny was involved in too, about unaccompanied asylum-seeking children in hotels and being transferred by the Home Office to a local authority where they've had no prior connection, where that local authority has not met its duties, where Kent County Council has just transferred the child to, has not accepted their duties either. And basically these children are described as not looked after by anybody. And so actually in those cases, we've been acting for local authorities against the Home Office. So this is a kind of new dimension to looking at how it is that Home Office policies that they're taking impact on local authorities' duties, the children who may be looked after, or maybe children as part of families who have, I mean, from my perspective, we've got immigration problems. Obviously, there's this situation with large numbers of people in hotels, and then when they get their status or when they don't, they're then made homeless. So I think it's really a good opportunity to be stepping back and looking at what's happening in the family jurisdiction and how local authorities are responding. Obviously not all of the issues where the person's got an immigration status problem and that yours are wider than that, but just coming from my point of view, given that you've got that big crossover client base, that seems to be an area where you know, thinking about things strategically and stepping back and looking at what issues are arising, generating a new way of thinking about why there's a failure, how can you go about challenging the failure. Yes, local authorities are endemically poor and have resource problems, but why do they have the resource problems given that they've got mandatory duties? So I think looking at that scenario, which is what you're dealing with on a day-to-day basis, and thinking, is this actually really also a central government problem because local authorities are being starved of funds? So having a wider look at why these issues are constantly arising, which may get a better solution. You know, the local authority settles the case, or they may make a decision in an individual case, but it doesn't actually address the systemic problems that keep repeating. So I just wanted to say that from our perspective, it certainly is an area that's cutting across are intersecting a lot with our public law and immigration teams. And one of the things that we've tried to do in Garden Court, which may be something as well that might help you with your practice, is we obviously tend to work in your specializations, but if you look across if you have a kind of wider way of looking at it, so we've set up a children's rights group, and people did that kind of informally, but we thought we're seeing all these different issues that are arising. If we're cross and then they intersect across different legal specialisms, if we start to think of it across our teams, it will actually help us. So I think that's why you've got people from Garden Court who do predominantly public law, immigration or civil liberties practices, but as well as specialist family practitioners who have these sorts of areas as part of their work, because we think that's the best way to think about litigation that cuts across generic problems that are arising. And I don't know if that's something that you've been thinking about within your practice as well, and maybe triggered you thinking to have this round table. So that's really just what I was going to say by way of introduction from where we're coming from. But maybe, one of you could just give us an insight into, why you've thought that this is a useful thing to do. I hope you still think it's a useful thing to do at the end, but getting an idea, like an overview of what you're thinking about would also help us, I think.
Yeah, I think that's all everything you said is what led us initially, Creed and I, when we had that conversation a few months ago, about us being fully aware that the childcare family departments are focused on this sort of stuff, and the public law departments are bogged down with good old Suella Braverman. But there's no crossover, or as much crossover as we'd like. And so the idea would be for us, for the teams to work together to identify and to be able to be confident enough to bring sort of public law judicial review stuff, so and get the help from you guys to be able to make that viable, because we don't want to go into something slightly in the dark as to not knowing the technical aspects of it. We're not going to achieve that in any time soon, because we don't do that day to day like we do protection work, immigration work. And the childcare family departments are again bogged down with their day to day, and their capacity of developing into public law solicitors overnight is also difficult, right?
Yeah, it's having that knowledge, because that's something that because you kind of know something doesn't feel right, but you're like, oh, okay, we don't really know what we do, what it comes under, and it's kind of then, being able to speak it over and be like, actually, do we have a go, do we not? And I think for us personally, we're seeing it more and more, the local authority in particular, are not doing what they're supposed to be doing. Yeah. And it's not just, minor situations, it's extreme, and the impact that it's having now on these children. So it's just equipping ourselves as well with the knowledge of what we can do, what advice, especially, we're all children panel solicitors as well. So especially where you're acting, you're representing a child, especially when you're representing a child directly as well, there's like so much more of a duty on you as a solicitor for the child. If there are any kind of, human rights applications, all of that kind of stuff, you need to be the one to bring it forward. So it's just having that knowledge and having someone, you can just have a quick chat with, and actually, is there a way that this doesn't do something?
Also, what stage you can bring it.
Yeah,
so that's something I'm not quite clear. Do I mention this during the course of proceedings, or has it got to conclude before we actually raise it? So that's something I'm really not sure on.
Yeah. Okay, and just in terms of your kind of client base, do a lot of your clients have an immigration related issue, or is it, or not?
I would say, I practice in Luton and Birmingham, and Luton especially, we have like trafficking cases, we have, sexual exploitation cases. So I would say quite a large amount there. Do you have immigration issues? Yeah.
As well. So it's like, so I suppose that's the other way of looking at it, isn't it? Is you've got a client who's going to have multiple different issues. You can provide them a better service if you're thinking wider about their whole situation. And one of the things that we were thinking of doing, which is a very practical, basic thing, and it doesn't directly address this, but it was and maybe this would be something we could do jointly, but if you have, immigration advice for family practitioners and family advice for immigration practitioners, because it also works the other way, that, we don't always make the most of the family context, or we don't, when you've got an immigration problem as well. And I know that that was something, Catherine's not here, but that was something that Catherine Cronin was especially sort of focusing on, because she unusually does do quite a lot of advice for local authorities on the immigration status of the child, because they don't know what they're doing, obviously. And quite a lot of the time with the children, whether it's children as unaccompanied children or children with families, they're nobody's thinking about the position of the child and their immigration status, so that they don't get that sorted out, which then exposes them to all kinds of problems later.
And sometimes, obviously instructing someone like that to do with advice, not even know the questions that you're actually asking, because that's not an area that we would have been exposed to. So I think, again, it's just asking those right questions to make sure that we've got it all covered. And obviously, what we can get funding for, what you can't get funding for. I mean, I had a matter in Luton the other day, and, they wanted to resolve stuff, but the mum's immigration status had not been resolved, and she couldn't get funding, and, to get a solicitor to help her. So the judge is like, well, you need to go and help her. We're not immigration specialists. We can't just go.
I think on the funding thing, it nearly always has to be. I think it's really hard to get the LAA to split it between the parties. I think it has to be the local authority who pay. And they don't want to. But to resolve the immigration status of a parent, or to get a granny in as a visitor to be assessed, or to place a child with a family member under an SGO or something, or who doesn't have, if the parent or if the carer doesn't have immigration status, is all quite complicated and does need to be funded by the LA realistically. And if a judge tells them to do it, they will, as you know, but it has to get to that point.
But they'll always be like, well, we need somebody that
Costs and time scales.
to tell us to do, it's not like it's all very long-windedly.
So maybe, that's kind of feeding, that's very much our experience too, that there's a huge need for those crossover issues for sort of mutual training across the board, vice versa training, so that we're all understanding how best to represent a particular client in both jurisdictions to make the best for the family case, but also obviously how that would impact on the immigration case, and having that knowledge and recognition that they do interact and how they interact is important. So maybe that's one of the things that, as a follow-up, we could definitely think about, if that comes out, if that's a useful thing. And then that might help with thinking about strategic challenges. If we could do some in-house training on housing and on immigration. Likewise, our family practitioners could do something with. We could do it jointly, with the solicitors, because you need both, obviously, don't you? Because there are funding issues as well as substantive issues, and so we could do that kind of joint training, if that's a useful thing.
When you mentioned housing as a slip of the tongue, Stan.
Yes, so that's another big issue.
Yeah, it's actually another big issue, because we often come across cases where a barrier to a placement is that the accommodation's too small, or unsuitable, or they're in temporary, or they're in one room in a shared house, and that's the barrier. And obviously they say, well, once you get the child you can apply, but then that's a barrier because no judge wants to place while you still have the prospect of a bed and breakfast after that. So it's that sort of, how you deal with that within proceedings, and the family courts just say, well, that's not our, it's nothing to do with us. We can't tell the local authority how to do anything here. So I think it is another area actually where, as well as immigration, it would be useful to have our housing team as well.
As is community care, obviously getting Section 17 assessments and getting assessments of parents to put more support in place for them.
But it is like chicken and egg. It's also mental health as well.
It is. We're setting ourselves up for a lot of training.
But so what would you do if you have a housing issue like that, that's kind of an obstacle to a child being placed with a family member? Do you have a housing team that you would go to? Yeah.
It's housing teams, don't we? It's Duncan in there. So yeah, we would approach that and see how they can assist.
Yeah.
Because the JR in that context from a community care, but the JR that could run parallel to the family proceedings would be a failure to assess judicial review under the Care Act or the Children Act if they weren't properly assessing somebody as a carer, for example, if they refused to do so. So there are, I hear your point about how a lot of times sometimes it's difficult to bring it while there's parallel care proceedings, but if it's a different legal point, it can be brought and run alongside. Usually it gets resolved by a parallel, they'll agree to assess or something to avoid the JR, but at least it has that effect.
Yeah, I mean, to simplify it from our side of things, the ideal situation would be having had some sort of training with family childcare directors to be able to identify, right, well, that's now public. We've done what we can. Sophie, over to you. And I'm confident enough to say, because of the team that I'm trying to develop who are keen to develop this, say, right, yeah, we'll take it over seamlessly, and then get council on board who kind of know both areas, and off we go. And I don't know how, I need to be realistic as to how viable that is in the short term, with progressive training and really devoting some time to it. Can we get this off the ground?
I've learned from working with Queen very recently on a referral that it's not that straightforward, because sometimes so the case that Queen had, correct me if I'm wrong, was referred to us for a potential civil claim for damages, but you were still in, the care proceedings are still ongoing, and we were worried about whether that would, that would impact, if we brought a civil claim against the local authority, that would impact the care proceedings and the way the local authority act within the care proceedings. So got to be careful with that sort of situation. And the other problem is that we've got 12 months. We don't, and the care proceedings are still ongoing, and I think the date was November something. So we can't bring a civil claim. So it's quite tricky in that respect.
I think it's very, as you know, you can either bring a claim for damages in the care proceedings. There's authority for that, or more commonly at the end. And I think you can. Well, you just identify when the date of the breach is, but I think it is sensible to issue even if there are ongoing care proceedings. Nearly always, and especially if it's referred from the guardians, the local authority will know it's coming. Somebody will have said something to them. But there's loads of Human Rights Act claims from care proceedings. There's far more civil claims than there are JRs. The breaches of Article 6 and 8, keeping them too long in a Section 20 placement, not removing them, not assessing the parent, all of that stuff. So yeah.
Literally, I think it was like in 5 weeks, it was 7 different placements. One placement, the care plan was, the final care plan is that all the children should be separated, and my child should not have contact with the siblings. In the meantime, they placed my child with the siblings because there's no other placements. And the harm that has not caused not only him, but his siblings, and he's been to explain to them why he's now going to leave. Yeah. And actually, when you balance it, it's better for him to be with his mum, who actually, when you balance the harm, than actually be in foster care, because
So if it's useful just to think through that scenario. So you've got a situation like that where you've been inappropriately placed in a way in which is contrary to what the assessment is in his best interest. Would you have to wait till the end of the proceedings for the damage to occur, or is that something where you can is a judicial review the right thing, or do you have to bring that back to the family court to say this is wrong and make the judge do something different?
So in that case, they were placed under Section 20, and then care proceedings were brought. Okay, placed under a care.
So it would be a welfare decision, wouldn't it? In the final hearings about what was in the child's best interest, and I suppose, I don't think you get that many. You would appeal, wouldn't you, a decision on that? But I suppose if proceedings are going on for a long time,
make an application to discharge the care order and place him back with mum.
Yeah.
And to be fair, the judge did because they were going to move his placement again for another 2 weeks for respite care. So they put the child, he allowed the child to be put to the mum for 2 weeks, but now he's been returned back to foster care until the decision, the welfare decision at the end. We've obviously now made an application for a psychological assessment to see what harm that this has actually had on the child, not only what's been caused by mum, but actually also the local authority. But yeah.
So that's a civil claim, I think. I think that's a civil claim.
Could be that or an Article 8 breach claim afterwards if you then have. But obviously in proceedings, I think it seems to me like the proceedings are your remedy, like you've done the application to discharge. But I mean, there's other things that occurred to me, like the role of the IRO in situations like this as well, who are always completely hopeless. I don't know whether that is not on your list, is it? I always think that I've got a case tomorrow.
It's not even us kicking off and paying for guardians, which makes it even better for us. But yeah, you are right.
Can I ask as well, if you're acting for the child, on whose instructions? So for example, my gut is saying this is a jailable case and your guardian's not supporting it, and the proceedings have concluded, so therefore your guardian falls away. Does it then fall on us to make that decision if you're acting for a minor? Because you know the clients, technically the proceedings have concluded. So from a funding perspective, that's an issue.
Litigation friend for a child then in a JR. So it's either the rules on litigation friends are either a family member or if you're stuck, the official solicitor.
See, for us, it's so many more hurdles that we've got to think about. And at what point do we make that decision? And how quickly do we need to act once we've made that decision? And what if your guardian, if it's in proceedings, what if your guardian doesn't support it? Does the onus then fall on us?
At that point, sorry to interrupt, if there's a potential JR, you'd refer them to us. The guardian would have no involvement because the litigation friend or OS would step in. The guardian would only be involved with the care proceedings. So, yeah, I think you'd be safe there.
That's good to know.
You've got a difficult
It's so complex.
I don't know if anyone else wants to contribute on that particular scenario. Is there anything you want to add on that?
Well, all I was going to say is you can use your family proceedings to tee up your Article 6.8 claim afterwards, as you said you were doing, by getting all your assessments, recording on recitals in the order what the judge said, any criticisms of the local authority, ask for transcripts, get orders disclosing bundles so it can go straight to the OS of the civil claim. All of that can be really helpful because they settle these cases quite early on if you've got all that, if you've got it recorded on the face of family judgments, how bad everything's been. And you've got a really grumpy judge, excellent.
So is there a kind of, because of your experience of dealing with that kind of case, you would have a sort of checklist in your head of this is what you need to be doing when this starts to go wrong. Is that something useful that you did for you guys? So that's something we could think about on that sort of situation.
To be clear about in proceedings or out once they conclude, isn't it? And I'm just in my head, it feels like it's very difficult to challenge within because the courts, and Grania probably knows better than me, is likely to say you need to deal with that within your care proceedings because they're welfare decisions. And it's only afterwards that but I don't know. I think it's an interesting question because it's obviously extremely frustrating sometimes when you have a bad judge to wait. And
it's not going to it wouldn't rectify the breach. That if a child's been inappropriately placed for 3 weeks and then moved, and you deal with everything in the care proceedings, and he goes back to the family member, such that the breach is only for 2 or 3 weeks, it's still a breach. And so you wouldn't get very much, and you may think about whether to issue, but it still is a distinct point that can't be rectified by the family court, I suppose, ultimately.
Yeah, so I'm just thinking whether you do it before you conclude or afterwards. That's the...
Yeah. Well, you have to do it within a year, so that's normally always the answer to the...
Yeah.
But yeah.
Sorry, Duncan.
Is that a year from when the proceedings began, or is it from the breach, from the date of the breach?
Is it not the date of the proceedings? Wait, who was it?
Yeah, because we had some stuff that was shared between the family practitioners group, and they said it was from the year from the date of issue, but that couldn't work. But then that's what I would have assumed it would have been from the date of the breach, because the year's nothing, is it?
Was that the CAFCAS guidance that you're referring? Yeah, it said on there, didn't it? Ideally, it should be from the date that they issued proceedings.
A year from issue. I think it should be from a year from the date of the breach, but often the breaches aren't fully clear until a guardian's appointed in care proceedings. So you can argue that the time runs from a different point, or you can apply to extend, etc. So that's all open, but I think it's probably better to be safe and issue and stay, or issue protectively if there's
We can send you the CAFCAS guidance if that would help, just so you can see what guidance they're giving out. I don't know if you've seen that, but we can send that over to you if that will help. Yeah.
But often the breaches happen within proceedings. After they've issued, if they've gone on to breach something else. So I thought that doesn't make any sense why it would be an issue.
I mean, if you have to argue it, it is an important point in the child's life that you can say crystallised or it became known, but I think it is safer to say.
I think what I've got in front of me might be the CAFCAS guidance that Katie.
It must be the same one, yeah.
It says that there's a 1 year limitation period, but it can be earlier than that date and it's fact specific. So I'm not sure what exactly that means, but.
And the process that they refer to, though, is slightly different, isn't it? Because they, in the CAFCAS guidance, they say you make a referral to the official solicitor, then the official solicitor will look at it and instruct somebody. And I think your case, I've spoken to Karina about the one that you're dealing with. I think she was going to recommend to the official solicitor that we use Duncan News because we've kind of dealt with it already and you specialise in that area. But I get the difficulty we may face is that the official solicitor may pick somebody else to instruct on behalf of the child, yeah, because they have their own solicitors who they then pick.
That does happen.
We can only recommend that, potentially say, you know, we're obviously dealing with the children proceedings, so it would make sense for it to remain because there'll be that interlink. But at the end of the day, it's up to the official solicitor, I think, to make that decision.
And the other problem is that they've noticed it can take them up to 4 months from referral to actually do anything. So
You're up against the deadline.
Yeah. From the 8th month, you've got to start. Then, yeah, like you said, you can issue protectively, and then you've got 4 months after that.
For notary claim.
So, yeah.
You have a lot of litigation against the official solicitor. Because they are so poor as well in terms of their delay, but that's maybe a different matter.
The only thing I would say about an extension of time is that I think that point tends to be resolved at trial. So in other words, it won't stop you running it all the way up to that point. And it won't stop you settling the claim. And because they're children in care, etc., you've got a very strong application to extend, even if time is found to be against you. That's the only thing I would say.
In this particular case, the court have now given us leave to actually just seek advice from you as to whether or not we have any grounds. So if that was the case, and then we had to instruct the official solicitor, if you're already involved, it's going to be more difficult for them, isn't it? If you've already seen the papers, you've provided that advice.
And you've got a strong argument. If it's going to take them 4 months to find somebody, we're ready to go.
So maybe we're going to kind of go around it. Right.
Just to be clear, these civil proceedings, you're happy, you want to refer those to us? Purely on the sort of damages, human rights breaches, that's one aspect that you want to refer on to us, okay? And just so I understand it, that's all sort of in my head, the kind of the immigration style. This is more after the event, false imprisonment, you know, getting money for your client. But what's happening if the child's being harmed and it's in the proceedings? You can't stop, other than you asking for an urgent discharge. But that's the way to stop that, i.e. trying to get in our world, trying to get a client released while they're in detention. You have to go through an urgent, and that's through internal
decision, then you have to appeal that decision.
And appeal to the court appeal. Okay.
Because it's usually a circuit judge that will these cases anyway.
Okay, so that's very much, so that scenario is very much you guys, you'll do it. But after the event stuff, pursue damages, that's one aspect that you want to refer on to us. Okay.
What's the issue with funding for like the jail stuff? Because I don't really know much about that at all, but how is that funded?
Certificated.
Is it means?
Yeah.
Do you need advice to get the funding? Or
it depends on how strong the case is. If we're off and running and we know that these are strong cases, then we do a statement of case. But generally, with the council, we instruct. They're happy to provide us with an advice to get it off the ground. In terms of means testing, I know it's different with family cases, isn't it?
So care proceedings is.
So I don't know whether, these aren't technically care proceedings, they're civil claims.
There'll be classic advice and
But I think that's when I tried to get this off the ground a few years ago, we had this problem with funding a lot because a lot of for children, it wouldn't be a big problem, but if you've got parents or a lot of them are on benefits, that will all be taken into account. And then you've got the contribution factor that comes in. Or if you're at legal help stage, you've got the issue that we can't, because our immigration and public law matters are means tested. So that's something that we need to think about as well.
And I'm sure a few years back, this was quite a few years back, we had a case where we were considering whether to make a human rights claim within the care, whilst the care proceedings were ongoing. But if that mother had recovered some money, the legal aid agency would say, well, hold on. So that's another thing that we need to consider, whether we do it within the proceedings or.
Yeah, that the statutory charge is. But it doesn't stop you referring the case and getting initial advice and considering it, yeah.
Or even if you needed to, if you did have you're running up against a deadline, a time limit, then lodging the claim, which then at least gives you the 4 months. And that's a hard deadline. You have to put the claim, serve the claim form. So you just lodge it with the court and then you have to serve it within 4 months, and you can't, there's no discretion on that. You have to do that, even though you could agree extensions for serving the particulars of claim, not for that step in the proceedings. But just going back to this scenario, I think maybe it's helpful to just look at some of your scenarios, because I think they kind of draw out this question of in what circumstances and when should you and can you bring a judicial review when there are ongoing care proceedings. So in that sense, it's looking at the kind of parallel responsibilities of a local authority when there's a care issue alongside their other duties to the child or to the family. So and where could you draw a principled line for saying, well, actually the care proceedings are not a remedy for this, and here is that you need a different form of remedy to enforce a particular duty that is impacting on the interests of the child or the parents in the context of the care proceedings. So maybe I was just having a look at the scenarios. Maybe even just a number of them raise this question, but so maybe it's helpful to kind of take a few of them and then see how we'd answer that question. So should we just start with the first one? And what you've identified there was there's a local authority can, with the consent of those that have parental responsibility for the child, enter into a voluntary agreement to accommodate the child under Section 20 of the Children Act 89. Where there are concerns that if the child remained in the care of those with parental responsibility, they may be at risk of significant harm. So does that really draw that question out?
that's outside proceedings.
Yeah,
so
that's not in proceedings. So let's have a look.
Is this question very nice that you want to have to
I think it's in relation to the local authority have a duty to make sure that everyone is represented, that you have that proper, authority from anyone that has parental responsibility, and they're not doing what they're supposed to be doing.
And there is a case law about that, isn't there? Yeah. A clear case law about Section 20. I mean, I don't know about you, but I do find that they are a bit better about it now, local authorities, because
For us in London, they're better.
definitely here.
Into legends them into it.
Yes.
I've just had somebody call yesterday that I spoke to, a new client. They don't speak a word of English, spoke to their adult child, and they said, our siblings have been taken into foster care. There's no court orders, no proceedings. Said, well, have you signed anything? Well, Dad signed something, but I don't know what he signed. They can't speak English. Well, was there an interpreter? Was it translated? No, nothing. He just signed something. They think it's to do with something to do with medical, getting seen by the GP. They don't know what they've seen, but signed. But the children have been taken and they're placed in foster care. And that's, I think, what we're trying to draw. I think with that example, it's a prime example.
That really does happen when mum has not just but she's been, signed a Section 20. and that you're being accommodated, and trying to get that information, and you've not even, you've not got somebody there to assist and nothing, you've just got to sign.
So that does seem like a JR issue.
Yeah, that's a JR issue, yeah.
That's unlawful use of section 20, but the problem is the remedy could be them just withdrawing their consent.
Okay. Yeah.
That's the problem, that if you were advising them, you would say, well, it's unlawful, but in practice, once parents get legal advice, they do often withdraw their section 20 consent.
And then they have to issue proceedings.
And then they have to issue proceedings, but it is.
At which point, non means non-tested legally.
But we need to see what they've signed, so we don't even know what they've signed yet. I haven't even seen anything. They don't even have a copy of that.
But there could be wider issues, as Steph said, in that particular local authority about how they deal with section 20s, how many people are being treated in that way, what their policies and practices. So there could be a wider.
And I think that we're cautious with this because now the family courts are trying to do more under PLO. So pre-proceedings, before they've got the court proceedings. So they're doing all the stuff that you would actually do within court proceedings. And at times, they've not even got solicitors at that point, which puts, very vulnerable clients in a very, before, you wouldn't usually do like psychological assessment, psychiatric assessment, up until you actually got to court proceedings. But now they want all of that done before they've even got to court. So, they don't know what needs to go in the letter of instruction. They don't know what actually entails out of an assessment. So if they're not then being informed of that information properly,
That's the choice of expert as well. We know which experts to keep away from and which ones instruct they're safe.
Yeah, I was going to say that was one of the things I wanted to know from you, because obviously by the time it gets to me, it's a sort of done deal. But what is the position in terms of funding for you to represent clients and PLA process?
Legal help.
Yeah. So you're quite limited on what you can do.
Don't share the costs of any experts' assessments or anything like that. That wouldn't be covered for legal help.
So is that more of a sort of strategic litigation type of thing at that point, isn't it? Because it's not going to be every local authority, but if you have a lot of experience of local authorities doing that, and I've had exactly the same thing, and you sometimes get there, but then you have to battle against them when you're in proceedings because they're completely pointless, a lot of the assessments, because they've been not done properly, not instructed properly, not the right questions asked.
Very one-sided.
to get another assessment because you've now got the whole necessity test and all of that, which is,
So that seems to me that's one where you can, because it's not really for us because we're already in it. But although actually, if you see them, and then you're fighting against them once you're in. But pre-proceedings, if you're seeing that happening, that's potentially collecting up evidence in relation to particular to the practice. Yeah, because I agree. I think the PLO I've got very mixed feelings about it.
It's an access to justice point.
Yeah.
Because all the case law about the child leaving the court and the appointment of the guardian and this judicial super, it applies equally to parents.
That is, one of the main things why please do not sign, because there's no one overseeing what contact. Most of these parents don't have contact for, months or weeks.
So just on that, is there guidance as to what they have to do to actually adhere to section 20?
Yeah.
There's clear guidance. So is this more a matter of them systemically breaching that guidance, or there is no elegant?
Yeah. And I think that's
Probably that the guidance is not, it's not right, that, that there's possible unreasonableness challenges to the guidance, which is the local authorities should be doing these assessments, when actually do we all think they should be, because actually parents aren't properly represented. So why do we do them pre-proceedings? I don't know enough about the PLO, to be honest. You come in and you see these assessments and think, why have these been done, actually? Or they've been done and they're reasonably helpful, but you then have to, almost inevitably, I find, they get repeated.
And I think that ties in to another, and I've forgotten which scenario it comes under, but you flagged up the issue of capacity, and I know I've had a couple of cases where there's been PLO, you get to care proceedings, and plainly one of the parents has at least questionable capacity, and it is a problem, because of course the social workers that are dealing with the PLO are not those who are necessarily going to know from the capacity assessments, and even unless unless the parent's actually been sectioned and then they can't avoid the issue, they're really, I think, probably quite a few cases where, well, just the cognitive difficulties or other difficulties do leave a parent possibly without capacity, and the local authority has just ploughed on with the PLO process. But I'm not sure whether that's anything that can be done at a time, or just something to factor into each of the challenges. That's probably, as we mentioned, the checklist, probably something to look at when you get the case in.
I think the PLO and Section 20 points are rife for individual or systemic challenge. So I think they're the two obvious ones to think about if you get a very strong case on its facts.
Just to explain to me, what's the rationale for this PLO arrangement?
To help the court, really.
Because you've got the 26 weeks that you have to finish.
You've got to get everything done within a time limit.
Really keen to get assessments done beforehand, so proceedings can be done.
Isn't it, as well?
Yeah.
Right.
So you've done assessments pre the issuing of proceedings, and then you're
without thinking through the impact.
straight through to.
Or in the hope that it will conclude and not need issuing, basically. I think that's the intention.
That doesn't happen.
Rarely, or it goes off for 1 in 100.
So I think any issue, obviously I agree that that's an access to justice issue, and if you do have any particular vulnerability for the client, for the parent, like a mental health problem, you know,
Which is the
majority, then you've got a Equality Act claim, because you've got to have anticipatory duties to make sure that there's reasonable adjustments are made for them to be able to participate in the process. If there's problems with access to lawyers or with any kind of disadvantage that arises, then that would be an angle of the claim, and that's something that you can also bring by way of judicial review. So we've done that in the context of people in detention with mental health problems. How do they participate in decision making about the decision to detain them or to segregate them, or something else that might happen? And the cases, it was in the Court of Appeal called VC, and we won on Section 20 because they were failing to make provision for any kind of mental health advocate, or that was the primary reason, but they simply hadn't addressed the disadvantages in the process for somebody with a mental health problem. But let me tell you, that was 2018, and they still haven't remedied the failure. So we had another case a year later, and they still haven't remedied it. And I heard there's a JR, but you know, that's there's that obviously applies, and there's a lot of it's a straightforward question, Article 6. If you can't, an 8 are obviously engaged at that point, but you've got other Equality Act duties that would help you with your access to justice issues that could be brought, that don't have to be brought as a civil claim, they can be brought as part of a judicial review. Yeah, so I think that seems like a very...
And if you're acting on behalf of the child in the PLO process, which you wouldn't be, but you're only in front of parents. So I think there are some cases. I know when you're for parents, you don't want them to bring care proceedings, but if you're for the child, if it ever, I think that there could, and this is a point Catherine raised too, there can be a JR of a failure to bring care proceedings, particularly for migrant children who they never bring care proceedings for, and who, if they were British children, would be subject to a care order.
Well, I've got a case where there's a 15-year-old, she's mother, she's child, so she's subject child in proceedings. She's had a baby in July, and the local authority said, we're not going to issue proceedings because it's going through the PLO process. And so we represented the children in the other set of proceedings through their guardian, and the guardian was livid. She was saying, can't overstep the mark too much, but we were wording it in a way to say, well, the local authority needs to issue for that baby because the concerns were of grooming, sexual exploitation, but the local authority didn't issue till about 4 weeks ago. And they'd placed that 15-year-old girl in a mother and baby unit, which was tailored to adults. And we were saying, well, what are you going to do about her schooling, her time out with her friends? She's still a child, but the assessment was set up in pre-proceedings based on an adult. But she was just 15 years old.
That's a classic example of the lack of protections in the PLO process, and that you probably could have JR'd the failure to bring care proceedings. but it got resolved. But even if sending a pre-action letter can help.
I think there's some serious concerns about the whole PLO process. I mean, I had one where the parents were criticised for poor parenting. This boy was out of control. PLO process, they didn't issue, and I got appointed for the child. And I was like, this child is ADHD. Has this child ever been assessed for ADHD? Because all of his classic signs, lo and behold, got an assessment, it was ADHD. So all the criticism of the parents was actually a child who she'd been trying to get assessed by CAMS for years and years and years and couldn't get him seen. So all the poor parenting was actually the local authority failing to actually get this child seen and diagnosed and actually then help him for the parents. He was removed unnecessarily. Had the proper help. But this is what we're seeing day in, day out.
But that's an interesting point for the PLO, because that, again, a failure to assess.
Failure to assess.
But
Should
it took me coming on behalf of the child saying, this child needs to be assessed. Straight away, I said it. I was like, he needs to be assessed straight away. Lo and behold, he was. But the social worker should have picked this up. The local authority should have picked this up, not me.
Yeah.
Sorry?
Was he in school?
He was in school.
Should have picked it up.
We're seeing failure. Schools are not picking
That
up.
child has
Social
a
workers-
damages claim now, doesn't he?
Oh, yeah, but
It's the local authority, school or everyone else.
Yeah, I've got
mean,
one
there's
tomorrow actually, which is in proceedings, but the local authority failed to do an autism assessment. And they failed to do it even since July, when we've had a psychologist who hasn't been able to do the autism assessment say there is necessary for it to be an autism. My solicitor is now issued for an assessment, but that's 4 months later because they sat on this assessment and recommendation and they put in evidence saying, well, we don't think it's necessary and they don't accept, the schools don't accept and NHS don't accept private assessments. So yeah, it's like, well, we know that's not true because you can get nice approved assessments. And so there's been another, and she's gone into secondary school. And so potentially this is a case, isn't it? This case Morris is a case for damages because this child has transitioned to secondary school in a way that's been described by the psychologist as will be extremely traumatic for her without an ECHP because she hasn't got autism diagnosis or the proper diagnosis and the ECHP plan.
I had another one very similar, same sort of kind of point where it was ASD and they didn't know he was ASD and they criticised the parents for not providing a nutritious meal for the child, a well-balanced meal. It transpired the child was ASD and would only eat white food, so potatoes, rice, pasta. And again, it took us to get into proceedings to represent the child to say, hang on a minute, is this child being assessed?
Care proceedings is increasingly, with all the local authority cuts, is increasingly the only way to get results for children.
Yeah.
Bizarrely, it's totally, and in terms of getting assessments, getting a guardian, getting people to properly review.
Well, if you don't get them in, you're not going to get it afterwards. This is the thing for this child. If we don't get that assessment now and we end proceedings, there's going to be no assessment.
Quick question, what the PLO process, is it a wider guidance or does each local authority have its own?
The president most recently gave everyone guidance saying that the PLO process needs to be. Yeah, it was kind of
Be across board.
But I do think some local authorities use it, like your Birmingham zone, whereas Luton,
Do you have any PLOs there?
Luton, everything's PLO'd up until.
Very, very rare. But then Luton, we've had absolutely
PLO'd,
But I
yeah.
think part of the PLO does come from the Children Act. I think there is some statutory basis for it, but it's also just guidance. I think there's a mixture of sources.
Well, it looks like, I mean, I don't know whether there's any research being done, but it does sound like even on its own terms, if it's actually supposed to be speeding up the process and or reducing costs, it's not doing either of those things. So if you've got, it's always good if you've got a challenge to obviously identify what you say is wrong in terms of the failure for the individual, but also it's not even meeting its own, it's not fit for its own purpose. That's always helpful. I don't know, are there organisations that monitor what happens in family proceedings, and is there any kind of way of no reports on
An NGO,
what's
that
happening?
kind of.
No.
So your referrals are straight through a DL referral?
I mean, I think there
Cacas, I give them my work from Cacas.
I mean, I think there is some academic research, but I think it's piecemeal, isn't it?
And it was kind of like it all came out first, didn't it, when it was first introduced,
Yeah.
and then it kind of COVID happened, so it kind of went away, and then it's like come back again most recently, hasn't it? It's given.
Maybe local authorities, sorry, I was going to say local authorities might be doing their own internal research, and they do have quite sort of they do have reporting mechanisms that you can find access to information where they've assessed it themselves. It's not easy to find it, but you can. So it may be that if there's a local authority that's doing it a lot, they will have to account for that at some point in some of their ways in which they have to report on costs for certain things. So it might be worth seeing if you could find something about what they say themselves about it.
The other issue we've got at the moment as well is that even after they've issued and the court makes the correct orders, which we've been mooting for on behalf of the child, you then have a local authority who don't have an option but to fail the child further because there's not enough regulated placements.
Yes.
So you're finding that children currently are being placed in unregulated placements because the local authority are saying we've sent out a search for over 120 placements and no one wants this child. So this child is then being put into an unregulated placement, being failed further, neglected further, and then we're left saying this child can't be in there. So you've got a local authority who's got the order they want, but then can't place the child anywhere that they want the child to go to. So they place them unregulated, and we're pulling our hair out.
Yeah, well, I mean, that's the sort of issue that we've kind of came up in this litigation about children in hotels. And obviously it's a criminal offence to put a child in an unregulated placement. So that's a big deal, but still it's happening. So if there are, what we've seen in terms of disclosure in this case about what steps the Department of Education, because they have the primary responsibility for making provision for regulated accommodation. And so there isn't just the local authority here. I think there is a way at also going to the central government, because ultimately, if there aren't enough places, that's not an answer if you've got a mandatory duty. But at the same time, it doesn't get you the solution, because where are the places? So I think that's a way of thinking about, well, what's the responsibility of the central government to make sure that they've got the resources in place for this to happen. And that's the kind of sort of new, it's not new, I mean, maybe others have done it, but I haven't seen any case law like it. But I think being able to not just bring your proceedings against the local authority when they're failing in that kind of circumstance, but also what's the Department of Education doing, and is it doing enough and effectively to make sure that there are regulated places? You can't have Parliament can't issue provisions that say under 16s can only be in this kind of accommodation and then the accommodation not to be made available. It's just not acceptable. It's a massive rule of law issue. And I think that those are really rife for it, but I think it's not just going against the local authority. I think we want to be looking at going wider.
I think that's exactly the point. I was in communication with the ALC last week, the Association of Lawyers for Children, and we're trying to, at the moment, in such a way, lobby the government about this point, because there is a serious failure by the government on these children. So I think the ALC are trying to, as a public body, trying to deal with it. And they're very aware. I spoke to them last week about my current cases. I spoke to them before that as well. So they are trying to deal with it. They are aware of the situation.
What are they, like a organisation?
It's like the Bar Association, the Housing Lawyers Association, Helper, but they're more likely to be heard than we are. Joe Bloggs going to the government, whereas because they are.
So let's say your client, the kids are in unregulated accommodation placements, you would then say they need to be moved, and they're like, well,
the court has said it. The court's made a secure accommodation orders, and we can't. There's no placements.
I just hate these cases. If you could find a way to run that, they are so sick and sore and exhausted of placing children in accommodation, which is totally unsuitable.
There's the new guidance that's come out as well, isn't there? That was just coming last
So
week.
in this particular case, the court made a secure accommodation order, couldn't find a placement. They placed her in an unregulated placement to the point where the judge was so concerned. This child swallowed 2 batteries. Okay, she was so concerned about her. The judge said to me, she emailed me directly, "You're for the child. I'm going to give you my mobile number. If you need me over the weekend, I will sit 3 o'clock in the morning till we were having a hearing to try and get an order for this child." It was just one of those cases we think we physically couldn't do any more than we've got. There's just no placement. They're abusing. I mean, the local authorities are paying so much money for these unregulated placements, and they're abusing the money as well. They're not using it correctly for that child. They've got staff going in who are meant to be supervising this child, don't know what they're doing. They don't know how to read the dole's order. They don't know how to implement the dole's order. So, what's the point of having it? So we're constantly fighting a losing battle.
Steph, I've got to go actually. I've got children, my own children's parents. But can I just say on that, the Children's Rights Department, Chambers that Steph mentioned, are doing an event on the 22nd of November. And one of the topics, it's about children in detention. But one of the sessions is on dolls.
I'd love to do that.
Section 25. So I'd recommend you come to that if you can, because that'll be a really interesting follow-up discussion actually. Because there'll be other lawyers there, criminal, immigration, detention. I don't know if you're involved.
Doing that in prisons.
Yeah, exactly. So I think that would be, you're probably going to say anyway.
Yeah, but I think that's really definitely something that can be litigated. I know there's a case that's been argued in the Supreme Court about, it's not in the context of children and not in the context of detention, but a failure consistently to meet the specific needs of this person. And the local authority have said, we just can't find accommodation for this person. And this is Martin Westgate was talking about it. So, and the Supreme Court is going to, they accept they've got a duty, but they say we just simply cannot meet it. And what's the court to do in those circumstances? So the Supreme Court's going to decide what it's going to do about exactly that. So, but, that's an individual case. And I think, maybe that's part of the reason why actually local authorities shouldn't only have to deal with this on their own. They need to be saying it's a central government issue. And seeing this disclosure about what the DofE does for its oversight of provision of appropriate accommodation, they definitely have a role to play.
But I think all the bodies involved don't actually talk to each other. So for example, this particular child, she ended up in hospital because the battery was still inside her, and they sectioned her and medicated her to sedate her. And I thought, this child doesn't need sectioning. There was nothing wrong with her. She was attention seeking. She was fully able to give me instructions. I knew exactly what her wishes and feelings were. Ultimately, she wanted to die, is the situation that she was put in, both at the unsecure placement, which she thought she was being failed at. Nobody was listening to her other than me. So I put her point across, but she didn't need sectioning. They changed from a section 2 to a section 3, didn't give her the paperwork, didn't give me the paperwork. And I said, I'm a lawyer. Why are you not giving it to me? Wouldn't give it to me. We've got a mental health team involved. They wouldn't give it to the mental health team either. In the end, suddenly she came off section. I said, I'm going to take this all the way up if I need to. And she tell me why this child's been sectioned. Lo and behold, they withdrew the sectioning.
It's quite an interesting point, because I was doing mental health law before this, and reviewing the section papers is such an integral thing, because it's not that uncommon to have fundamental issues in the section papers that make the whole section legally invalid, then giving them rise to a claim for damages, or meaning that they can be freed or have to be assessed at once more. So that's quite interesting.
Honestly,
they were refusing to give you section papers.
They did that even though were there ongoing inherent jurisdiction
They
proceedings?
got a mental health lawyer to go to the hospital to speak to her. They would not give the lawyer the papers. But can we see what basis she's been sectioned for? Wouldn't give it to us.
If the child has the capacity to instruct a mental health solicitor in those
She
proceedings,
did. That was what I got for her.
then they have to give it.
They didn't.
Gives permission to the lawyer
They
to
didn't give it to her.
Yeah.
I've got it all documented. This is one of the cases that I want to take further. We're still in proceedings, but this is one of the cases. Yeah, we'll talk about it after. But I've got many like this. I'm going to come sit over there.
In October, the provisions relating to regulated accommodation for over 16s is coming in. So that there was a change in the law that removed the additional quality of accommodation that was necessary for children in care over 16. They're putting that back, and there's no way that local authorities are going to be in a position to meet those obligations. So there will be a whole load of extra children who are going to be in accommodation that's that's unregulated and can't be regulated. And again, the government was saying that they've made some contingency, but it's bound not to be enough. And anyway, money is not the only issue here, is it? It's also actual physical space. It's also about what you need to, as you described, the appropriate qualified people to be looking after children. And that's the other thing, that they're just not going to be able to do it. So that will be a huge area for potential litigation. And given that it's about to come into force, that, and if the government's provision for that is inadequate, then that might be something that is also, we could be looking at. You have it over 16, it's over 16, isn't it? It's over 16, 17-year-olds who could be in unregulated accommodation.
Yeah, she's 16. She's literally 16.
Can I ask about her? So she's still in care proceedings now?
She's still in care proceedings, yeah. And she's insecure at the moment, and she's finally moved to secure, and now they're looking to put her into long-term residential until she reaches adulthood. And then move her to semi-dependent.
And it was a Section 9 judge in care proceedings.
It ended up going all the way up and then dropped back down again to circuit level. Because it just spiraled out of control over that whole 1 week, 2 weekends.
Because they just do not have the appropriate.
They just don't have the appropriate, and they were just failing this child constantly. Everything they did was just failure after failure after failure. And I was in communication with the local authority lawyer all the time, because we were literally on a WhatsApp because we were so concerned. She's like, Kathy, we've got nowhere to put her. I can send you a copy of a screenshot of all the push-outs that we've done. I think they call them push-outs, where they send a vast, I don't know what they call it, but they just send a case summary of what the case is about. They send it out to all these placements saying who can take this child. There was no one available. Nobody took this child.
They're putting kids in like caravans or Airbnbs with care agencies coming in. The Airbnbs, they just book online the way we would if we were going away for the weekend. I mean, it's complete madness.
Where a child is not high risk, the local authority, Croydon, have actually got a crisis room within the local authority offices where they can't get foster placements for the children. So they actually put a bed, a TV and a side cabinet within local authority offices, because sometimes they can't get foster placements.
Croydon, well, I think a local authority clinic would be good on those types of issues, as you say, Steph.
It's crisis. It's
Let's say there's nothing they can do and the Supreme Court says something unhelpful about that. Surely they still all have civil damages claims for just being inappropriately housed, the harm it's caused to them. I mean, and the other question I had is, why is it HRA claims? Is it not no PRA claim?
You could bring in a judge combined negligence and HRA claim, yeah.
Okay, so then that's not as.
I think legal aid, well, I always get a bit confused whether it's easier to get legal aid for HRA claims than, I'm not sure, but yeah, you tend to.
This is an area that I've always been scared to deal with, because I didn't know enough about how to approach it, so I think this has been really useful.
For legal aid, it's, if we can establish higher damages, it's easier to get legal aid because of the cost benefit. So if we're limited to HRA, the damages are maybe relatively small, we would struggle with cost benefit. But we're bringing in PI.
Well, I mean, this girl has a PI claim.
Yeah, I mean, that's a lot more and therefore easier to obtain.
How does it work with, how does negligence work in those situations though? If it's not a breach of statutory duty, is it? You're not going to get those claims off the ground. So what is it they've done negligently? They just can't find a place.
Yeah, and it's after that what's the case, HXA?
Yeah.
Or yeah. Well, I think I've definitely pleaded it, not in failing to find placement cases, but in failure to remove or other cases. So I think it can at least be looked into. But a lot of the cases settle just on a HRA basis and are. But if you do have distinct PI claims that you can back up with evidence, then.
Yeah, there is case law that says that under the HRA domestically you should apply the equivalent civil damages rather than looking at the Strasbourg case law is very low damages. But here we've got case law that says it should be parallel to a tortious claim. So even like an Article 5 claim, if the child is detained, we may have a false imprisonment claim. Possibly, I don't know if it's not been done properly and all of that, but also there is Article 5 case law about conditions, and if those are unacceptable, that can be a breach of Article 5. So even if there's a lawful power to detain the child, if the child was held in conditions that were wholly inappropriate, and obviously if they were damaging to their health, that would cross that threshold. That would be an Article 5 breach as well. There's a proportionality element, got to be in appropriate conditions where you can have access to appropriate care. So that, yeah. Okay, so we have another look at a different scenario. Let's see if we can find one that is within care proceedings of the kind that we were saying, where we might address that question of, is this appropriate to go by a judicial review? Sure, is a good one for that.
Number 6, maybe?
Yeah. The child is made subject to an interim care order and removed from the parents, however the placement is not culturally appropriate. So the example that's given there, who's a practicing Muslim, but is not able to practice their faith. Is this a real case?
So it was a 15-year-old child was placed separately to the rest of her family. So mother and her 2 siblings were initially placed in a refuge. Mother had disclosed the address of the refuge to the father, so they had to move her from there to a hotel room. The 15-year-old girl learned GCSEs, but she was not in a culturally appropriate placement. She said that she wanted to fast, she wanted to wake up during the night to eat, to close her fast in the early hours of the morning. The foster carer said, well, we don't really know what's going on about that. So she was saying to us, well, they're not allowing me to observe Ramadan. And the foster carers were saying, well, we don't really know anything about it. What do you want us to do? We said to the local authority, you have a duty to promote her religion as well. Try and place her in an appropriate foster placement, or at least give the foster carers some guidance. Same was with mum. She was in a hotel. She had no cooking facilities at all. So she wasn't able to do anything either. So it was, and this was the one that we were concerned about, whether we issued HRA claim in proceedings. It was the child and the mother were both looking at it because what would happen with the stat charge. So that was a bit of but this was quite a few years back when I was newly qualified, this was. So one of my supervisors were dealing with that, but I think this is kind of stuck in my head for quite a while, because local authority were just like, well, we don't have anywhere else to put her. Well, at least try and give the foster carers some guidance then as to what they need to do to support her. But she was then saying, well, I'm not able to observe fasting, or,
I don't know, Rachel, do you want to have a think about that? I mean, is that something you'd raise within the care proceedings rather than as a separate challenge?
Well, I mean, I think if that was going on, you would raise it, and it's something where, the judge might make a comment about it, or it might be, that might help the local authority to realise if, they're meant to be providing guidance to the foster
The judges don't really, all they can do is give an indication,
Exactly,
or make a comment toward, they can't order them.
No. But I suppose, obviously, the reason we were looking at it was this question about if it's in proceedings, what can be done within proceedings. I mean, I think with something like that, it would be less of a, obviously it depends how long it went on for, I suppose, in terms of, it might be appropriate to have a sort of separate challenge around it. But hopefully that's something that could be resolved within proceedings without.
I think ultimately, I suppose the backstop remedy there is simply applying to discharge the ICO. It doesn't necessarily help. Well, the girl has to be accommodated, so it's not going to necessarily move her if there are genuine reasons somewhere else. But at least the court then has an application at which it has to formally consider the interim care plan.
If there was a situation where the court didn't see that as a big deal, or the local authority said, well, there's nowhere else we can put her, at that point, what would be the next port of call? Can you appeal an interim decision?
It depends if the judge has actually made a determination on it, then
They've done that.
So at that point, could we possibly?
It's about keeping that child safe. And if they can culturally match, I can't even get the word out. They will. They always try to. Especially on the case that I've had, they always try to match the child with appropriate foster care. But sometimes it's just simply not possible. And so I think the court's concern would be that child needs to be kept safe. And it doesn't matter if it's not culturally matched, if the child is safe.
Yeah, the court doesn't approve really specific foster placements. It's just in principle foster care.
Yeah. So why was the child and the mother could have been together, but
there were concerns about forced marriage, so that's why the child was placed separately.
So there was no way through by the local authority having to house the mum in an appropriate environment where the child. No, so that's not going to happen. Yeah. Okay.
So I suppose there's a difference, isn't there, between the cultural matching point, which obviously is, like you're saying, that they try and do that.
Right.
But then this example where it's not just a lack of cultural matching, it's like an actual kind of, you know, having prevented from observing Ramadan. So is that something about, like, if you'd wanted to observe Ramadan, the foster parents would have had to sort of facilitate it by, you know, getting up early as well and helping her with the food or whatever, and they weren't willing to do that. I don't know what the kind of, there is, it would be interesting to know if there is specific guidance on that kind of issue.
Well, the local authority has a duty, don't they, to promote the child's religion and religious beliefs. So essentially, I think we were going down that route, that they were obviously failing on those grounds.
Yeah, I think ultimately in a situation like that, it's probably not going to be litigated because it's providing a safe accommodation is the requirement, but because they didn't have a place available that was within a Muslim household or a household that would understood and respected those, it's not a direct discrimination case, and you could justify the fact that that child had that discriminatory experience because the priority was to safeguard them. So I think you would have, it's much more of a, I mean, obviously you raise it within the context of that, but I think that would be a difficult thing to bring separately, either as a civil action or as any form of judicial review.
This may be a silly question, but in this set of facts, I mean, would it not have been possible for the local authority to have moved after this to say another family that wasn't Muslim but was more willing to respect her? Because you would have thought most
anywhere
families,
else. They said they
there's
didn't have
literally nowhere
anywhere
else. Okay,
And she needed to be close to the school because she was going through GCSEs.
Oh, okay, yes.
So they didn't want to move her too far out because it was such a crucial time for her. They needed to find somewhere that was close by. So there were a lot of different factors, but we weren't sure whether this was something that,
It goes back to lack of placements. And I'm finding more and more that siblings are being separated into foster placements at the moment because there's simply not enough placements to place them all together. Sometimes 2 children are being separated, and you're like, really? Do you really have to? If there's more than 2 children, guaranteed they're going to be separated. So you've got in each other's houses all day long, and then suddenly just see them.
They'll separate them, then order it together in a part assessment to look at the effect on them afterwards. And 6 to 8 weeks later, after they've been separated, what's the point in doing that assessment at that stage?
It's also like, we've got 3 children and place 2 of them together.
And the younger one's separate because the younger one's more likely to be adopted. You're like, really?
On that, then a failure to assess.
And then the issue is if they don't have the place, and if they don't have,
It's all just yet to be in proceedings, and the court will we normally request it.
and again, it's the availability of placements again, isn't it?
Yeah, so it's just a huge problem, isn't
It's
it?
a massive problem. Lack of placements is a massive, massive problem.
Yeah.
Mainly for us.
Yeah. And the difficulty with challenging that is that it isn't just a provision of resource, is it? Because you've just got to have the people willing to do it. And they can't force people to become foster carers. And otherwise
could I possibly raise a separate issue? Hi everybody, James here. I do understand, of course, that where there are ongoing family proceedings, that the remedy for breaches, etc., is in the course of those proceedings. Just wondering if anyone's got any guidance or thoughts on questions where the proceedings have come to an end, even some time before, but the local authority suddenly starts acting inconsistently with the order in respect to the end of the proceedings, as it were. That's what happened in my case, where the order set out, these shall be the arrangements, and they shall only be altered in one of 2 circumstances, neither of which applied. And the local authority just ignored us writing and saying, well, you're breaking the law. I was in doubt about 2 things. which meant I gave them much longer than I would have liked to have done to get their case together, because I was reluctant to start judicial review proceedings because I was concerned that the remedy would always be to go back to the family court even long after proceedings were finished to say that there was a breach of the order. And then, as a slightly related point, when it looked as though that was going to be necessary, I finally decided I think that has to be the right answer and we're going to have to do it. And I stilled my courage to do so, not being familiar with the family procedure, but being pretty clear that when a court order says you've got to do this except for A or B and A or B don't pertain, I was worried if there was any restriction on a right of audience or any form of accreditation or something that you may need in order to appear in front of the family court to argue that the defendant is not following what was set out in the order. In the event, the extra time meant that the defendant suddenly reversed spirited and it was all resolved. But I've been left with this question hanging around in the back of my mind ever since.
Yes, maybe would you apply for a discharge of the order of the care order, right? If they're not, and then as part of the proceeding.
No, well, the order was what we wanted. The client had obtained the order that they wanted. The problem was the local authority were now purporting to decide to no longer follow the order.
What were they not following, James? What did the order say?
Well, it provided various visiting rights and arrangements in respect of the child and my client, who was a parent of a child who was placed in looked after accommodation having special needs of quite an extreme nature. And from the terms of the order, it appeared that it was bitterly fought for my client to have obtained all of these carefully delineated rights to visit and do various things on her visits. And the local authority suddenly turned around and said, we're not going to do this anymore. So I assume that to deal with the issues one at a time, I assume that must be go back to the family court and not start a JR that you're behaving unreasonably. I assume that must be right.
I think you'd make an application for is section 34 contact the child in care to revisit the existing arrangements. That's probably what would be the first step rather than JRing it.
Yeah, because it sounds as if there was a care order, then the local authority will simply have reviewed it at the lack of review and made whatever decision they did, so that there may or may not be a reasonable basis for the decision, but if you want it before the court, that would be the better remedy.
But that doesn't seem to answer the point. That whatever the local authority's reasons were or weren't, the order explicitly stated that this order the local authority shall only not follow this order in either circumstance A or circumstance B, and neither of those apply. So rather than reopening the question of what the assessment of the child's best interest is, surely it's a matter of just saying, well, this is the order of the court and you need to follow that. It did provide a procedure whereby the local authority could go back to court if they wanted to vary, which they were not following. So I'm confused about the suggestion that it would be for us to start a new action. Surely the action has been decided.
I think it's quite unusual that an order, was it definitely care proceedings? It wasn't complex private law children, was it? It's quite unusual that because best interest is always subject to review, it's unusual that it would say A and B in those circumstances. So it may be that there's something more fact specific about it, but I think normally that's the issue of contact and how it happens is always subject to change for a child, and so it wouldn't. I think probably it would be hard to go to a JR or think about contempt or something, because it's in family they're not bound like that for a period of time, because it will change depending on how the child is or what happens. Or
okay, well, I mean, I'm not a family expert, and I'm using care proceedings in a layperson's sense. Proceedings in front of a court in order to decide upon the accommodation and living arrangements for a child. I mean, I assume those. I hadn't realised those might not be care proceedings. It
could be a dispute between the parents where the local authorities have to get involved.
So what you're saying there is it's not really treated as a final order. It can always go back and be reviewed.
Yeah.
More likely to get specific details in private law proceedings, aren't you, than final care orders.
Okay, I don't know if we're going to get any further with that, but I mean, thank you. Thanks for raising that. There is another kind of private law context which might be just worth looking at, which is number 5, which it says, in order to sort out the finances of the divorce, teachers and NHS workers need a Form ECTV in their pensions. The public body that the information comes from has a backlog, and they're not providing a form and stopping vulnerable people, especially those who've been subject to domestic violence, from moving on. So I don't know who's raised that situation.
Family directors, but they're not here. It was Julie, because actually she was dealing with one of my brother's partner. Actually, she's GP, DV in the relationship. The divorce has been dealt with, but they can't sort out the finances because of this document. She's made several requests, and then there's a backlog. There's nothing that we can do. And then Julie and I were looking into it, and actually the BBC just around that time had published a report basically dealing with a lot of people in the same situation.
They should have some kind of expedited process, shouldn't they, for really vulnerable applicants?
Yeah. And not having that would be a public sector equality duty issue if you could sort of say that where there's a need for urgency for this to be sorted out, it's more likely to be for women who domestic violence. It could be, I mean, obviously there's a number of ways in which you might raise an issue about that.
She can't sort out, she is scared to sort out the children proceedings because she doesn't want to have a backlash. She wants to sort out the finances because she doesn't. At the moment, he's agreed to what he wants, they're agreeing it, but she's scared, but they're having issues in relation to the children, that if she issues an application under the Children Act to make proceedings, then he's obviously going to get his own back on the financial side of it and then go back on what he said. But she can't sort that out because of this document, one document.
But she does have access to funds. It's just the pension. She's not destitute as a result.
No,
it's just she needs to have his pension
to sort out
the proof of the information to resolve the issue.
The finances.
I feel like that it's an interesting issue that could be good, and I wonder if it's good. A DV victim is good, and I think it would. There probably could be slightly stronger facts though in terms of the impact on her. I don't know. There may be other people with similar.
Because it might be that you can't do this, and therefore you're not adequately not access to adequate subsistence money. Yeah. So that could be a factor. Yeah. Well, yeah. I mean, those sorts of delays that have that kind of impact, potentially there's an issue there to be pursued against the public authority that's failing to do that. Yeah.
We'd be sending reps to them, to setting it all up, to know, writing to them and saying, consider this not X, Y, Z. You'd have to set it all up.
Okay.
Yeah. It's an amazing array of problems that you've identified. It's where to start and begin. I mean, you've got a few about the other one that I think we might have covered this in 7, which was about children placed under section 20 for a prolonged period of time without the court, without seeking court proceedings. I think we definitely think that is reviewable, isn't it? Wherever that arises. And as we said, we've been looking at the position of unaccompanied asylum seeking children and the fact that they often fall, you know, they don't seek care orders for them, they're just looked after. That is going to become an increasing problem or issue because of the new provisions of the Illegal Migration Act, which give powers now to the Secretary of State to accommodate unaccompanied asylum seeking children. And they can do that by directing a local authority, and they can do that by taking over the inverted commas care from a local authority. And so this whole question about the status of unaccompanied asylum seeking children is really, it's going to become much more acute. I mean, maybe it does have an impact for them, and there is a benefit always of a care order rather than just a section 20 situation, but now it's become much more acute. So that's something, if you have a caseload of children, unaccompanied asylum seeking children, to think about that, because it could protect them from going into home office accommodation, especially in a context where whilst we've just litigated this issue and they can't lawfully put children outside of the care of the local authority in a hotel, they've given themselves this new power. Whether that means they want to then keep accommodating them in hotels, because that takes the burden off some local authorities like Kent that are over-pressured, overstretched, and there aren't any foster carers and foster places. They've got a big problem with under 16s because, again, as you've said, foster places are a premium and are difficult, but putting them in a hotel is the most inappropriate place they could find. They disclosed in the proceedings their own assessment that they had done, which said that not having a child straight into the care of a local authority exposes them to risk of re-trafficking, because we know from the hotel experience that large numbers of children went missing. A number of those children are still missing. A number of them have been found to be in situations of criminal exploitation, re-trafficked. So if you're thinking about, if you've got the number of children on your caseload, it's really worth at this point having a look and thinking about a strategy for asking the local authority to take them into care as opposed to just section 20. And the other issue for children is that if they were to implement the full extent of this new legislation, they can detain children. Any children are coming by small boats, that's the focus of them. It's not limited to them, but that's the focus. And they've given themselves powers. They haven't yet set out the regulations to detain children, and also to make the regime much more harsher for children who become over 18, that they're going to be removed. So if they go properly into the care of a local authority, that may well protect them in a way that they're not at the moment, both from being accommodated in appropriate places, detained, and or potentially their longer immigration situation is undermined by that. So I think that's something to think about.
I agree, and that's something the public law team can ask the family law team, because if there's children on your books, so kind of migrant children who aren't in section 20, who are living with a family friend or somebody in the community, and the placement has no legal status. In other words, there's nobody with parental responsibility for the child. That if the child goes to hospital, there's nobody to consent for medical treatment. You can JR that against the local authority in terms of whatever way you need to argue it. So it should be a section 20 placement, or if not, they fail to properly care plan for the child. And there's a whole raft of ways they can define the placement. So they might want it to be a special guardianship order or a private fostering arrangement or something, but at least the result is to get the child a sort of formal legal status in terms of their placement, because there's hundreds of them who just are nothing in terms of the Children Act, which isn't lawful. They have to fit into one of the categories.
Yeah, so that's a big area, and it's now become much more of a pressing need to have that status. And obviously also they have duties to them until they're 25. So, you know, there's a lot that's lost by not having that formal status with a local authority for that category of child. I think another issue that we had raised when we were looking at this, which might be something that you said, it was about traffic children at risk of using traffic. When did we raise that?
I think that would have been Catherine.
Oh, was it? Okay. Yeah, I think that might be a similar concern that local authorities are not assisting the child to make protection claims, trafficking claims. That
you mentioned you come across trafficking.
Yeah, so it's more like the parents that have been and they've obviously had children, and the reason why they've had care proceedings issued in this particular one was the mum had suffered with disorder, and that had an impact on her care of the child. And as such, the local authority had then obviously got involved. Necessary assessments were done, and in the end, thankfully, we were able to, keep the mum and baby together. But yeah, that's usually. But then we have had, haven't you? You've had cases where you've had the girl that was sexual exploitation, just your most recent one. So yeah, we have had cases.
Are these British parents, or are these parents with?
My one is immigrant. That might mine wasn't.
That's when getting an immigration advice in the care proceedings, because obviously it can comment on the parents' immigration status, and then somebody could advise on whether she needs to make a trafficking claim or an asylum claim, or
there's quite a lot, to be fair, in the Luton area. We've got the nail bars, and we've got a Romanian gypsy, very big community, Polish community as well, Bulgarian community as well. We've had 2 mothers that were trafficked most recently in relation to that particular case. So yeah.
When the courts are making those assessments, does sort of Article 4 cat duty come within any kind of assessment? Is that even a thing within?
Yeah, so that's where the kind of way in which, in an immigration context, that's so heavily litigated, but it doesn't get read over into this context.
And it's not even something that the local authority think about when care planning.
Or even the experts who do the assessments, because they're asked to comment on anything else that they think may be relevant, but even the experts don't comment on it.
it's just about parenting, that it needs an enhanced focus.
Can you tell me what pages in the Dropbox bundle the client care letter is, and whether that was in any of the
Muted.
also in any of the PDF attachments?
How do I?
It wasn't. We just raised this.
It was or wasn't?
It wasn't. So yes, sorry, we're just raising this as this was we were thinking, when we looked at your examples, we were kind of thinking of what are the categories of cases where there might also be an issue. And then generally in that context, it's about the local authority failing to recognise that they've got a duty in the context of their care planning or in safeguarding to address these issues and their immigration status. I mean, there's a massive need for local authorities to be actively and proactively pressing to get status for children, which they don't. And that then exposes them to they're in an inferior position. And it's also kind of mad for them, because whenever the child doesn't have status, then they remain much more of a financial burden on them. They can't work, they can't kind of get on with their lives. So it's a sort of, if they thought about it properly, it would be a shifting of some of the burden on them away from, that they just don't look at it like that. And so they end up with a young person who will be in an insecure limbo sort of situation for many years before things get sorted out, if they don't proactively deal with that. So again, that's kind of something that is that you could initiate, say they need to take that on board and they need to do something about it. And if they don't, that's the kind of thing that can be reviewed. And that can have a huge impact, positive impact for the child. But it may also be that
use the threat of proceedings for them to start to think about it and to change their practices.
Because in the Aylesbury area as well, we have recently had quite a few cases where children being involved in modern day slavery, county lines, which we've not had within care proceedings before, but in the Aylesbury area, we've started to get quite a lot of that happening recently as well. But again, it's just, they're not thinking about all these other things. And it's just very much, like you said, from the perspective of just the care plan and what needs to be done here and there.
And are these again children with insecure immigration status, or is it mixed?
One of them was, two of them aren't.
Yeah, so I mean, the one thing to recognise is that if you are a victim of modern slavery, that in itself is a basis for having discretionary leave to remain, and that should follow. That should be, you know, obviously you should make the referrals into the system for an assessment, the NRM, but then if that's recognised, then and there's going to be a lot of evidence produced in the proceedings, you're going to have evidence that will cross the threshold for them to accept that. And the follow-up should be, and this person needs, or this child needs, status as a result.
I'll ask you a really fun question now. You know, because obviously they focus a lot on sorting out the immigration status of the parents. So will the child then automatically, if the situation in relation to the parents has been addressed, or would it be that actually that is attention that they need to?
I think they do need to look at the child specifically, yeah, because the child may have a different interest and a different outcome than the parents.
Especially if they're placing the child away from the parents.
Yeah, and that's key. I mean, we have a lot of cases where the child's been in the care of a local authority and nothing has been done on their status, and then they get into difficulty with the police, and then they face deportation, and it's just a sort of, you know, self-fulfilling thing.
Even the one that I've just finished, and it was a trafficking case, Luton, and they obviously, in the end, there was two sisters, one husband, both had children. Both sisters had children from the same husband, and luckily, you know, at the end of the proceedings, they were saying that the children could stay with the mothers, but they were very, very heavily focused on resolving the issues in relation to the mother's immigration issues, not so much the children.
It may be that in a lot of cases they're interrelated, so it ultimately wouldn't make that much difference, but sometimes it does.
So, but that again is a point that we
need to just focus on. It depends how old the child was. You know, children who were young. Yeah. But, you know, like a child that's here, born here, and is 10, is entitled to citizenship. So they don't want to have the same status as a parent who, you know, who might just get some limited leave. So it's always worth looking at. And obviously the critical problems is where they're not with their parent that gets the immigration status, or they're just left and nothing ever happens until it's too late and some adverse consequences have arisen. That's how when we see them.
Mm-hmm. But basically, failing to sort out immigration status for children in care or care leavers is a potential JR-able.
Yes, no, definitely. Yeah, so I don't know, I think we sort of set aside a couple of hours, which we've nearly come to, and we haven't gone through all of your examples. Is there any like really pressing one that you think would be really helpful for us to sort of look at, to draw out anything that we haven't covered in this sort of session?
I've had one recently where a young baby, 6-week-old baby, was removed from parents' care due to suspected non-accidental injuries, so a bump to the head. We've had the medical reports back in 2 weeks ago, which states that it was a birth-related injury, and it was not an inflicted injury, but the child is still in foster care. We sought for the child to be returned to mother's care because the main issue was this suspected injury. But is that something that we could pursue on the basis that this baby has been away from the parents for almost 6 months now?
An interim that happens.
And when was the decision that they're completely cleared in terms of concerns?
Well, we've just had the reports like 2 weeks ago. We had a hearing last week and we sought for the child to come back to parents on the basis that, well, actually, this injury that you're saying never actually occurred, it was birth related, so that child should come back home, but the child is still in foster care. The court made a decision that actually there are wider issues, but it's just in terms of the reason why that child was removed in the first place was because of this suspected injury, which turned out not to be an injury, but birth related. So is that something that
The court has ordered for the child to be returned now? Is that right? No, they've got the concern, so the child is still separate.
But the basis of the local authority's case initially was just on that injury. So the doctors at the hospital had said, we can't rule out that it's an inflicted injury. Local authority issued proceedings, that baby was removed. But 2 experts have now come back to say it's very clear that there is no, absolutely 100% that this is a birth related and it's not an inflicted injury. So that child has obviously been away from, you know, it's only 6 weeks old when the baby was removed. I don't know if is that something, because I think you had a similar one, didn't you?
I think your civil claim is a bit weaker from, unfortunately, the fact that the judge later authorised the ongoing separation. And sometimes in those non-accidental injury cases, the local, has everyone accepted the report, or are they going to get everybody's accepted? Oh, everyone's accepted.
Do you know what the other reasons are? Are they
Domestic violence surrounding DV. But when their threshold made no reference to DV, it was all to do with this suspected injury.
But they are.
So, but why can't they place the baby back with mum or dad, whichever one, in a mother or baby foster placement? So the baby and baby's parent or child?
Well, the baby was initially with maternal grandma for 2 weeks. Then they realised maternal grandma was in this pool of perpetrators. So baby was removed from maternal grandma.
I think I would take a long-term view of that case when it came to the end, in terms of looking back over the breaches and how it panned out.
I think the problem is, although they didn't mention it in the threshold, the local authority is entitled to rely on after acquired evidence. So, you know, if they discovered something of concern post the first removal, then they are entitled to rely on it. I mean, there may be, as Gloria says, there may be something that you can do, because it doesn't sound overly reasonable. This is one where the father was in the hospital with the baby.
No, that's a different.
That's a different one. That's a
Mine was that one hadn't even got to proceedings yet, and they literally didn't allow even contact, because there was, you know, one of the doctors said maybe it's potentially non-accidental. They were kept in the hospital for 10 days because the local authority couldn't make their mind up as to whether or not to issue or what to do. So the child could have been released literally the next day. So he had another child as well. That child had to be placed with another family member. And then mum, she would, when all this happened, she was going through a miscarriage. So she was arrested, then she bled out at the police station, taken into hospital. And during the time that she was in the hospital and the child was in the hospital, she was not allowed to she wasn't allowed to see the child, and the child wasn't allowed to see mum for 10 days.
I think that's an Article 8 breach.
Because even supervised contact can be relatively easily arranged.
What about in these? Because I had a very similar case to Rapinda. So, baby presented at the nursery, had a bruise on the bum. So they obviously issued care proceedings, removing from the parents, and then didn't really. I mean, they didn't. In relation to the, you know, obviously placing with a family member, no, it's too much of a risk. The bruise actually was, you get nappy cream, the yellow one. I can't remember what it's called now, but anyway, that's what it was. No, it's got something, it's up there. And it was actually that, in the end, that got the actual. So this time that this baby had been apart from the parents, would there be anything that they could do in relation to that? I mean, it could have placed the baby with another family member, supervised, you know, have them being supervised. It wasn't as though those were in the pool of perpetrators, but having those significant months where the baby was away, while obviously expert reports were undertaken.
So I think there's civil claims for all of those, but the problem with civil claims is the parents don't care when they're in hospital and they can't see their baby. They want something more urgent. I definitely have perhaps, like said, pre-action protocol in some non-accidental injury cases, just to maybe to put the pressure on local authorities. Rather, I'm not sure how successful we'd be if we actually had to go to the High Court. But I think getting funding and sending a pre-action letter can be on things like contact, the way in which they're doing the investigations, failing to follow up on certain inquiries, failing to look at an expert report properly.
And this is the point, because really they wouldn't even know to get like a lawyer involved at that stage, and that's just all happening. You know, there's no way of seeing exactly what the local authority is doing.
Yeah, and then there's huge consequences, aren't there? Imagine, you can't even imagine what it's like to be separated from your child for a day, never mind, you know, a week or 2 months or 3 months or longer. It's just horrendous. But I think maybe it is. I mean, they're not going to be used to being litigated in this context, are they? And whilst there are some local authorities that, you know, sort of fight hard in some cases, housing cases or whatever, I think it probably is going to be a situation where a properly good drafted letter will make a difference. And I suppose that's just like kind of getting yourself organised to do this. But once you have got into the routine of doing it, then it's not going to be, you've got to take instructions and everything else, but it, you know, it's something that could make a really big difference to your clients, isn't it?
Having like, because you get loads of these kind of types of things. I mean, you know,
I think having a template would be good, because it can then change the course of the family proceedings. If you're really, really robust to begin with, they don't come to court not knowing what they're doing as they normally do on their first, you know.
And just place them with family members that actually just not separate it, you know, and finding different ways, because you can, can't you? There's different ways that you can, you know, think about and make it work so that there is no separation. It doesn't have to just be.
It's very rare that there's nobody else
Yeah.
that can step in to help.
Well, they've got people now, haven't they, that can come in and supervise 24/7, yeah, live with you.
Or do they do other?
Yeah, they've got me in Bedford. I don't know if they've got me
I
in
can't
Bedford.
imagine my horrific personally.
Is it not a sort of 24-hour nanny? Is that not what that is?
There's times when I could have done with that. All right, oh, fine, you're here.
Albeit they're keeping notes, sort of suspiciously looking at you the whole time.
Yeah. Yeah. Okay, well, I mean, obviously that's, you know, I don't know if it feels like it was a really useful discussion. It feels like there's a lot to follow up on. I mean, we can obviously look at the notes and everything, but certainly the training, we could do that. The kind of checklist for civil actions and what you should be noting and following through when you're in care proceedings that you can see are going wrong and there are delays and Article 6.8 issues. I think the key thing that comes out of it is that this, I can't remember what you called it, the PLO, so that's the right thing at this moment in time, it's on everybody's mind. But, you know, if that regime seems to definitely be something that's ripe for a challenge, and following up on that, definitely. Section 20 and care orders, making sure that process is undertaken, that seems to be another obvious area that would have some really good benefits, particularly with identified unaccompanied asylum-seeking children. Trafficking victims, again, looking at their particular situations and the duties of local authorities. And then I think the other big area is obviously where there's just delays in or failure to provide appropriate accommodation, whether that's in the context of secure places or unregulated accommodation. That's a massive area, and it's going to get bigger because of the law that's coming in October. So I think we could have identified 2 or 3 big areas that we can definitely follow up on. And you know, sometimes it might be that even just the being able to run your issue by somebody, that kind of relationship is an important one too. And we can, you know, think about how we might formalise that. I mean, obviously you'll do that with people that you know, but if you're trying to build up expertise and you're trying to get a sense of confidence about, look, this I feel is wrong. Is this something that I can do something about? I think that's a good sort of, that's a sort of support.
Kind of that doesn't really feel right, but there's not what you can do,
there isn't there? Yeah. And yeah, keeping the sorts of records that you've done of where there's common issues. It's definitely for judicial review proceedings.
yes, it's important, obviously you've got an individual case which may generate a case, but if you're identifying recurring issues, that's where you're more likely to be thinking, actually, this is somewhere where we could do a judicial review. So keeping your own kind of tabs on what issues are arising, what are common, that's a useful thing to do.
Especially if there's one local authority who's really bad with PLO or Section 20, because the individual cases probably, a lot of them will settle.
Yeah.
Will get resolved on their facts, whereas the bigger issues.
Yeah, and sometimes just raising the issues on an individual basis, even if they settle, starts to generate the evidence that you would need for just saying, actually, this is a systemic failure. So the next time it arises, you might have got to the point of issuing the proceedings and you're not going to concede it because actually, this is a problem that's arising a lot of times and you can evidence it because you've had 4 or 5 cases where this has occurred in the last 12 months or something. So you can kind of build up through your own individual case load evidence base for a wider challenge, so that you're not just having to constantly deal with, you want to make a change across the board, but obviously making the change for an individual, even if it's only writing the PAP letter that means that you get the child, they look for alternatives and avoiding the situation you described at the end. That's a massive impact, isn't it, for the children and the families? So yeah, seems like having that as a integrated part of your work would make a big difference, wouldn't it? Yeah.
Very helpful, thank you. And I think amongst DL, we'll meet again pretty soon to talk about current cases that you've got concerns, and then we can.
I definitely picked up at least three big issues that are definitely open to challenge from what you've told us. Yeah, okay. Yeah. Now you have to eat the sandwiches.